Hi, can folks hear me?
Yes.
My apologies for being a minute late here. I just walked back into my office here. All right, if we're ready to go, work sessions are an opportunity for board members to discuss issues informally with staff and invited guests. The board encourages members of the public to attend work sessions and listen to the discussion, but there's generally no opportunity for public comment. Members of the public wishing to address the board are welcome to do so during the board's regularly scheduled meetings. So we have 4 items on the work session agenda. We're going to juggle things around a little bit because I think we have some conflicts later. So I think the first thing we'll do is the county manager update. And then we'd like to do the discussion about land use, Board of Appeals case and separate materials, because I believe we have Chris Crean, legal counsel, that's joining us. And then if we can move to the biannual Clatsop behavioral healthcare update after that, and then our agreement with CBH following that. So Director Baker, if that's okay with you, we'll just kind of move things around a little bit, but we'll start with the county manager update.
Good morning, Chair Cuello, members of the board. I just wanted to share, I had a conversation with Ariane Colombo yesterday about a grant application that Colpac has been working on for some middle mile fiber build out along Highway 30 that would also go up Cornelius Pass Road and into Hillsborough. And this would be a public middle mile. And they are applying for a federal grant to substantially fund that. But there is an opportunity for the county to help support some of the matching funds and just support the grant process. So I'll be talking to your board about that as I learn a little bit more of the details, but likely sometime in early September, we'll be asking your board for some support for that project. I did want to mention that there is a lot of other work going on regarding internet connectivity through Charter, who got a federal grant to expand their presence. And so they're right now working along Highway 30 in the Svensson, Napa areas, as well as John Day, and then along the 26 corridor. So there are things happening, and we'll try to keep your board updated as we learn more about all those projects. And I did want to mention that next week we'll have some new staff who will be at the board meeting for their introduction to your board, and that includes the emergency management director who joined us Monday, Justin Gibbs. And so we'll have Justin at the next board meeting. So that's all that I have. Thank you, Chair Cuello.
Yeah, thank you, County Manager. Any questions for our County Manager? Okay, we'll go ahead and move on to the next item, which is the discussion about land use Board of Appeals case. We have some separate materials for that. I'll turn it over to our County Counsel, Joanna Lyons-Antling.
Good morning, Chair Cuello and members of the board. I will note that Chris Crean, he's a special land use counsel, and in fact represented Lincoln County in the Briggs County Luba case, which I kind of gave you the citation in the agenda packet. He will be joining us here shortly. I don't see him yet, so I was desperately trying to make sure he had the information. But I will let you know, I've read the case. Chris will have an interesting perspective on it. Basically last week, the Oregon Court of Appeals reviewed the arguments both for and against. Oh, I see Chris is now on the line, so we'll give him a second to come on board. But they reversed the Lincoln County ballot measure on short-term rentals. And so, like I mentioned, Chris Crean represented Lincoln County in that case, and he is here for you to ask questions of. Chris and I have discussed it in advance, and along with our community development director, Gail Hendrickson, and he can provide some insight on how this applies to Clatsop County. So with that, I'd be happy to turn it over to Chris.
Turn on my mic there. Good morning, board. Thank you for inviting me and the opportunity to hopefully help you address some of these issues. I think it, in my mind, just sort of the way my mind works analytically, I could walk through the recent Lincoln County case and how it was decided, and then try to apply the lessons of that case to yours to see if it provides any, guidance in your decision making. So, gosh, where to begin? When I got a call from Kristen Ewell, the county council, she said, we just had this ballot measure passed and we're anticipating a legal challenge. Would you mind defending the city or the county? And I said, no problem, we can do that. Well, that one case became 4 LUBA appeals, 3 circuit court cases, and 1 currently parked at the Court of Appeals. So it became a big deal. So if it takes me a minute to wrap my brain around it, that's why. So the decision came out this Monday, and LUBA ultimately concluded that this ballot measure that was drafted by county residents and approved by the voters could not basically violated the nonconforming use statute in Oregon law, specifically ORS 215.130. And the reasons are twofold. First, the first decision was whether the ballot measure was even a land use regulation, because as you know, your county code consists of multiple chapters, a whole lot of regulations, but only a portion of those are actually land use regulations subject to the state land use planning laws. And a lot of jurisdictions have regulations governing short-term rentals that are not part of their land use regulations. And if that is the case, then LUBA never gets involved, and those state laws governing the land use planning program, including Chapter 215, do not apply. The problem in this case was that the people who drafted it specifically said that on the date the ordinance becomes effective, anybody with a valid short-term rental, that automatically becomes a non-conforming use. They also added language in the purpose section that said these regulations are intended to ensure that these zones are in compliance with the county comprehensive plan and that they're consistent with the purposes of these specific residential zones. And based on that, it was impossible for LUBA to conclude that the ballot measure was not a land use regulation. Clearly, it was intended by its own terms to implement the comp plan and ensure that certain residential zones remained residential. And then it declared that those uses were non-conforming. At LUBA, we said that the statute, and by the way, the statute 215.130 says a lawful non-conforming use may be continued. Period, full stop. So if you're doing something that's lawful under the zoning ordinance and the regulations change in a way that doesn't allow it anymore, let's say you've got a gas station and the neighborhood gets zoned residential and gas stations aren't allowed anymore, you're allowed to continue, notwithstanding the change in the regulations. And they said by phasing out the short-term rentals, it violates the continuation requirement of that statute. And at LUBA, we argued that these aren't non-conforming uses under the zoning ordinance because the zoning ordinance doesn't address non-conforming uses, it doesn't address short-term rentals at all. And whether or not something is a lawful non-conforming use is determined by your zoning ordinance, not by other licensing requirements elsewhere in your code. You might require, a liquor store to get a license from LCC, but that doesn't make the liquor license, make the use necessarily something that's regulated under your zoning ordinance. LUBA looked at that and said, yeah, not so fast. In the absence of anything else, maybe that would be right, but the ballot measure itself expressly says on the date this measure becomes effective, these are all non-conforming uses. And there's only one definition of non-conforming use in the entire county code, and it's in your zoning ordinance. So these are clearly considered by the county to be non-conforming uses for purposes of zoning. And as such, that statute applies and they have to be allowed to continue. And so by trying to phase out the licenses, it effectively violated the continuation requirement of ORS 215.130. And LUBA ultimately concluded because the ballot measure and the state statute could not both operate at the same time, the state law takes precedence over the local ordinance and the local ordinance is preempted. So that's how LUBA got to the conclusion that the local ordinance is preempted. if they had not, when they drafted the ballot measure, had not put language in there about the comprehensive plan and achieving the purposes of residential zones, and if they certainly had avoided the term non-conforming use, LUBA would never have gotten involved. This would have been an ordinary county business regulation, not a land use regulation. We would have litigated it in circuit court, and I'm pretty confident it would have been upheld. We already know from Lincoln City's example back in 2015, 2016, that Cannon Beach's example back about the same time, that you can phase out short-term rental licensing. But once something becomes a land use, then it's subject to that land use statute that allows it to continue. So if you want, one of the lessons is obviously, if you want to phase out short-term rentals, keep it out of your zoning code. So applying these lessons to your case, it's not the case that your code is silent on short-term rentals, as was the case in Lincoln County. Your code expressly allows them in Arch Cape. And by implication, then they're not allowed elsewhere, because the county board clearly knows how to add short-term rentals to your zoning ordinance. And so the decision to add them in one place but not elsewhere means they're not allowed in those other zones, which means those licenses that were issued in the other zones were issued in error, but it doesn't make the use a lawful use for purposes of the zoning ordinance. In fact, they're not lawfully established. The licenses were issued in error, and presumably you could just refuse to renew them, because once you recognize that you're making an error, you're not obligated to continue making the same error. So I don't think the analysis from the Lincoln County case applies in your case, right? The whole non-conforming use analysis is very different, because your code does address short-term rentals and they're only allowed in one area. If you tried to discontinue or tried to amend the Arch Cape portion of your code to remove short-term rentals, arguably somebody could say, I have one that was lawfully established, and so I get to continue doing it, notwithstanding the fact you've now made it an unlawful use in Arch Cape. But that's not my understanding of what you're doing. Instead, your proposal is to allow them in the other zones where licenses have been issued, is effectively validating the licenses that are out there. I just don't see that there's any legal problem with that approach. And again, alternatively, if you just took them out of the code entirely and said short-term rentals are not allowed in unincorporated Clatsop County, the only place you might have a non-conforming use problem would be in Arch Cape. And you might have to allow some of those to continue. So you can allow them in all the zones, or you could prohibit them in all zones. Either way, I don't think that the Lincoln County case has much bearing on your circumstances.
Okay.
Right. Part one, any questions?
I think we've got a couple, at least Commissioner Thompson's got her hand up. So Commissioner Thompson.
Well, thank you, sir. So I wonder, in the legislature, legislative intent plays a role in this. I was on the County Board of Commissioners when we did this thing in 2018, and we recognized that there were short-term rentals in the rest of the county. There was, at that time, no mention by the County Board of Commissioners of any intention to disallow them in the rest of the county. Does that play into this at all? Probably not.
Probably not. Probably not. So, I mean, because the county code just is not silent on short-term rentals, as was the case in Lincoln County. I mean, your zoning ordinance specifically contemplates them in one area and nowhere else. And it may just be, I don't know what the discussion was in 2018. What did anybody bring it up that it's only allowed? My guess is the board looked at it just through a business licensing lens, and it didn't occur to anybody to check the zoning ordinance, right? But if
not our planning director, not the commissioners, not the county, nobody, that did not occur to people. Thank you.
Commissioner Bangs.
Commissioner Bangs has a question.
Yeah, firsthand, I have to turn off my camera because my Wi-Fi is struggling pretty hard. Secondly, so in 2018, the Board of Commissioners allowed short-term rentals in our county code in Arch Cape. Now we're here in 2022, and we've just had the second reading of our new ordinance. And so where does that put us? Like, I feel like the waters are very muddy right now. And so I'm trying to just find clarity of what are our choices moving forward from this point now that we've had the second reading of that ordinance.
So I'm not super familiar with the contents of that ordinance. My understanding is it amends the zoning ordinance to allow short-term rentals in a number of other zones throughout the county. And that if it's been through second reading, my understanding is it's been approved by the board, and you can decide to. I mean, does it have an effective date on it? Has it gone into effect yet? It has. Joanna's nodding her head. So it's basically a county law now, the new ordinance. And you can, there are options going forward for enforcement, for administration. You can decline to administer it by, doing another moratorium resolution that directs staff not to issue any licenses until a certain date or until something else happens. Lincoln County's had one in place for the last several years. I understand Clatsop County has had one in place for a little while. So you could continue that until any legal challenges are resolved. Probably a good idea, because if the ordinance is challenged in court and found for some reason not to be valid, and you've issued a bunch of licenses based on the authority in that ordinance, then you've got all these licenses out there whose status is then questionable. It just kind of creates a mess that will have to be cleaned up. So it's my understanding that there are opponents who are trying to get enough signatures to refer it to the ballot. If that's successful, you might want to consider a resolution suspending issuance of new licenses until the ballot, until after that election, just to avoid the sort of administrative headaches and problems that would arise if you continue to issue licenses under the ordinance. I mean, alternatively, the board always has authority to go back and revisit any ordinance or any law that has been adopted by this board or any other. That's obviously what you're there for, is to make laws for the county and revise them as necessary. So, I mean, you have a legislative option. You can go back and revise the ordinance if that's the will of the board. You can suspend operation of the current ordinance until any legal challenges are resolved, or you could just go forward and assume that it's a county law like any other and admit and apply it as written.
Thank you, Mr. Crean. Before we go back to Commissioner Bangs, County Council, did you want to add something at this time?
Oh, I think Chris has pretty much covered what I wanted to say. In fact, your board did address the legal conundrum that you faced a few months ago. And the ordinance was enacted by your board to allow short-term rentals in those specific commercial and residential zones outside of the Arch Cape zone. And so your board has attempted to address that. I think, as Chris has noted, right now we know that there is a potential referendum that could go to a future ballot. Signatures were not turned in, sufficient signatures weren't turned in for the November ballot. So we know it won't be in November of 2022, but there is some additional time for petitioners to gather the signatures to put it on for the ballot. And I think, as Chris noted, your board, of course, has several options. At this moment, your board has chosen to extend the moratorium until December.
Thank you, County Council. Commissioner Bangs and then Commissioner Thompson. Commissioner Bangs.
So I'm just trying to look at this as how can we move forward without muddying the waters further? In regards to, yes, we solved one legal conundrum through this ordinance, but we potentially have opened other legal conundrums, who knows, potential referendums. I would like to come out of moratorium at some point, but on the other hand, I appreciate the knowledge that it could potentially, by issuing additional licenses, it could potentially muddy these waters further. But I will be honest, I feel like we addressed the good neighbor policies. They've barely had a chance to see if they work or not. We're contemplating caps. I feel like we're doing good work. I don't know. This whole issue has taken a number of years, and I would just like to be able to put other issues in our staff's hands to solve, because I don't know if this one is solvable to everybody's pleasure.
Commissioner Bangs, I would be remiss if I didn't point out that I've seen a lot of county boards and city councils get completely wrapped around the axle on this issue. It's a hard one. And in terms of moving things forward, I think the fact that this board has actually made a policy decision, memorialized it in an ordinance and approved the ordinance does move things forward. You've made the policy choice. It now enters the next stage, which is resolving any legal challenges to it. And there's a decision to be made whether you want to just freeze things in place while those things are worked out. But I think the fact that you made a decision, the policy decision, is progress, at least from my perspective.
I agree. Commissioner Thompson?
Hooray for the county manager. This is slow going. It's kind of like chewing concrete, right? So what I'm thinking about is perhaps more appropriately Commissioner Toyoka's question, but I'd reached out to an old friend of mine in an attempt to offer compassion and comfort and empowerment, and it went badly. So I'm not going to do that anymore. What I'm curious about is the role of HOAs in regards to this, because we have an HOA in Surf Pines. In my mind, they exist to address these kinds of issues, but they're declining to do that. And so their residents, some of them, are coming to us for county action and county relief. In my mind, asking county taxpayers to be responsible for what the HOA already exists to do isn't the best use of taxpayer money on a county-wide level. Can you speak to that at all?
Yeah, so interestingly, one of the issues raised in the litigation that LUBA did not address, frankly, and I think it barely deserves mention, but one of the arguments they raised was that a number of HOAs have CC&Rs, their internal documents that expressly allow short-term rentals, and this ordinance would have violated those contracts. In doing so, violated the clause of the Oregon Constitution. That completely inverts the law. Private contracts don't get to dictate what public law is. If your documents allow you to, one of the things that you often see in CC&Rs is you can't hang your laundry outside. So if your CC&Rs say that you can't do that, but city code allows it, and you hang your laundry, you might violate your contract, but you haven't violated any public law. In other words, both can apply. In the short-term rental context, if their CC&Rs allow short-term rentals, but they're prohibited by local ordinance, then you can't do it, notwithstanding the fact that your contract would otherwise allow you to do it. So what might or might not be in some of these HOA documents has no bearing on the county's regulatory authority in this instance.
Well, let me ask specifically, can the county defer to CC&Rs? It sounds like maybe not.
Well, if the matter were I'm not sure I understand. If short-term rentals were not regulated by local ordinance, then they would be controlled by private agreement. But I don't think you can have a regulation that says they're prohibited unless they're allowed by private contract. That would be delegating the county's legislative authority to a private agreement between private parties, and you can't do that.
County Council and then Commissioner Webb, County Council.
Yeah, Chair Quayle and members of the board, I think specifically we're talking about maybe one or two particular HOAs. And we've talked with residents, kind of globally, that if your CCR does not allow short-term rentals, they would look at their HOA and their homeowners association and CCRs. The county doesn't have much impact on that. We're not going to enforce those CCRs. But if a group of community citizens wish to prohibit or limit or do something to restrict the numbers, cap the numbers of short-term rentals, that's something certainly that the HOAs have the ability to do. The county won't regulate that. And just to add a little bit more information for Chris, certainly that's the kind of the messaging we've been putting out there. So.
Yeah, thank you, County Council. Commissioner Webb.
Yeah, now that we're into the HOA and CCNRs, I think that one of the big impetuses for this outside of Arch Cape has been the difficulty that HOAs feel they have because they have a very high bar for virtually any regulations in their CCNRs. Some of them have up to 75%. And so they are and have told us that they are looking to us to help them out here. And I think that one of the issues that we are struggling with really is that we went ahead and passed this ordinance 2205. And of course, we did it without caps, which I was very much opposed to. And it unleashed after the board passed the ordinance, we unleashed the initiative for about the the initiative came forward. So I thank you for the information that there was that there were not enough signatures for that initiative. I wish we had been told that. I was not aware. And I really appreciate it if things like this get told to us immediately, because I probably get a dozen emails a day on this issue. And so I really need to be as informed as possible about that issue. I'd like to ask Chris Crean also the issue about what is your recommendation for the fact that we have been discussing the fact of prohibiting or capping STRs west of 101 in certain zones. What happens when we do that and the same zones exist east of 101?
On that subject, two things. Taking the second one first, your business regulations can include locational identifiers, some of which might be zone boundaries, for example. That doesn't make your business regulations land use regulations. So for example, Lincoln City's STR licensing provisions call out specific zones where they will issue licenses. And LUBA concluded the fact that you use the zones as a way of identifying the location where these regulations will have effect, doesn't turn those regulations into land use regulations. So if you want to identify in this, I'm making this up, but in your R1 zone west of Highway 101, here's the cap. The fact that you've called out a zone by reference to your zoning ordinance doesn't make that regulation a land use regulation. It's still a business regulation. And we would, if anybody challenges it, we're going to circuit court. So that's just in terms of drafting it. I think you'd be fine doing that. The second question about caps is a question more broadly of how to implement caps, particularly in the face of a situation where you've already issued a lot of licenses, right? If the cap is higher than the number of licenses out there, no problem. right? You keep issuing licenses till you hit the cap. The problem arises when you, and I should say, Cannon Beach and Hood River, I know, are two jurisdictions that use caps, and they work just fine. But they imposed those caps long before the number of licenses issued got to the cap. So trying to impose a cap that's lower than the number of licenses issued is more difficult. And maybe it's not difficult in your case because you could reasonably conclude, I think legally conclude, that those issued outside of Arch Cape were issued in error and just not reissue them. And that would get the number of licenses out there back way down, right? And then you impose your cap and the number of licenses would then slowly ratchet up to. But if you don't want to go that route, then you have to rely on attrition or some other means of slowly reducing the number of licenses over time until it gets under the cap. And that could take a while because a lot of these short-term rentals, it's my understanding, are owned by corporations or businesses that just renew it every year. That's their business model. And those licenses aren't going to go away anytime soon. So it may take a while for attrition to get the number of licenses down to the cap. And in the meantime, you wouldn't issue any new ones, right? So managing a system where you impose a cap that's lower than the number of licenses that are out there brings with it a lot of administrative headaches, but there's no legal reason you can't do it.
Okay, I'm sorry, I don't understand the administrative headaches. I guess for me, it was an equity issue. If we, Joanna, help me out. Didn't we lower the time period for licenses in 2205? We
Yes.
lowered them, right? We lowered them to a year, didn't we?
Commissioner Webb and members of the board, we actually reduced it from 5 years for every area outside of Arch Cape to 2 years.
To 2
So
years.
yes, but
So-
that would only be upon issuance of the new short-term rental permits. Those that are currently operating would still continue to operate under their current permit, which was a 5-year permit.
Wow.
So, but they get reissued, right? It can be reissued when right.
But the issue then becomes that if it's presently a 2-year issue, the folks who are presently are within lower than their 5-year period they don't have 5 years. They have just whatever they have, which is somewhere between 1 and 5 years, or 0 and 5 years, I guess. But if we start then not allowing those folks to renew their licenses, that's the only way we can bring them down.
Right.
So is there any kind of a problem with that if we have people under 5-year licenses now?
So from a legal perspective, what you want to do is make sure you have a policy for the circumstances in which you will renew a license and those circumstances you won't.
Yeah.
You absolutely can't do it on an ad hoc basis. This one, it's Tuesday, we're not going to reissue on Tuesday, but we will on Thursday. I mean, that's arbitrary and capricious, and you would get sued quickly and lose. But you could, if you make a policy determination, we're not going to renew any license in this area or any license for, I don't know what the basis would be to, you could say we're not going to reissue a license to, there'd have to be a rational basis for distinguishing those circumstances when you would reissue a license and those circumstances when you don't. And I don't want to start freelancing on what those reasons might be, but
a simple cap couldn't do that. If we had an area where there were 40% STRs and we wanted to lower it to 30%, we couldn't just say to an applicant, sorry.
So my problem with that is this. Let's say that you're setting a cap of 100 in a particular area, and you've currently got 140 out there.
Mm-hmm.
Mine comes up for renewal in January. I can renew because we're well under the 100. By August, you're bumping up against the 100. So if somebody's license expires in November or October and they come in to renew, it's too late. You've already hit the 100 cap. So it it's not equitable through across the calendar, right? Those people whose licenses come up earlier will get renewed. Those people who come up later don't get renewed. And that seems to me to lack any kind of rational basis.
County Council, do you have anything else you wanted to add on that?
Yes, I just wanted to also add, the statement was made that enough signatures were not gathered. That's not entirely correct. The time frame for gathering signatures is 90 days after the ordinance is adopted. Your board adopted the ordinance on June 22nd. And according to my quick math, that would be September 20th. So those folks have the ability to gather signatures for at least another 30 days. My statement earlier was they did not gather and turn in enough signatures by the deadline to make the November 2022 election. We don't know if they will obtain enough signatures for the May 2023 election. So just wanted to add that little bit of clarification.
So they're still out there gathering signatures. Okay.
Okay, Commissioner Banks and then Commissioner Toyoka. Commissioner Banks.
I would cede to Commissioner Toya because he hasn't had a chance to speak quite yet.
Okay, thank you, Commissioner Banks. Commissioner Toyoka. Can't hear you, John. Can't hear you. Yeah, sorry. I guess you do get your turn, Commissioner Banks.
Well, alrighty then. I just wanted to make up that I appreciate Mr. Crean's outlook regarding the inequity that would occur if we went down the route of, gee, I'm sorry, you didn't renew your short-term rental soon enough. These other short-term rentals, they came due sooner, and so they get priority. I appreciate not wanting to go down the route of choosing winners and losers in this conversation. That whatever we do moving forward doesn't say, oh, gee, I'm sorry, you didn't renew soon enough. I feel like all of these landowners have property rights, and I don't want to infringe on what they have currently going on their property. Be it short-term rentals, be it, agriculture, be whatever it is that they're currently doing and they've been doing within a permit. I don't want to suddenly pull that carpet out from under their feet. I just don't think that that's, I would protect basically anybody's property rights, be it agriculture or short-term rentals. It's not that I like or dislike the topic, it's just that it circles to property rights for me. But moving forward, what I'm gathering is that we have a heavy administrative load. If we start, falling further down this topic line, and creating, well, this region gets this and that region gets that, and that zoning code gets this and that zoning code gets that. I'd really like to be able to keep this simple for our staff moving forward, and with always the thought process in mind of we are serving in a county, we are not serving specific regions, and so we can't give all of our administrative hours to single regions. We have to serve this as one giant rural community, and so I just, moving forward, want to be very careful that we keep fiscal responsibility in mind, staff hours in mind, and if I gathered this correctly, an HOA or a municipality can make their own rules as long as they don't circumvent county rules. Am I correct?
On the last little bit, yes, the rest is a policy call. How you want to regulate business activities within the county is a policy decision for the board. But yeah, if you adopt an ordinance, it has to be applied equally across all affected persons.
Okay, I appreciate that. I'm a lot of that, what I stated is personal perspective, but the last bit there, it circles back to if an individual region wishes to have tighter control over a short-term rental situation, that becoming a municipality or developing an HOA would help them self-identify a little bit more than what I feel we can do as a county with our limited staff. So thank you.
Okay, thank you, Commissioner Banks. Commissioner Toyoka, do you want to try it again there?
Can you hear me now?
Yep, we can. Yep.
Okay. Actually, Commissioner Banks just addressed what I was going to discuss. First and foremost, thank you, Chris, for a lot of the clarification. Really appreciate that. It was about HOAs, and if you have a homeowner association that does have anything written in there about short-term rentals or rentals, anything less than 30 days.
None of them.
Excuse me, Commissioner Webb, you had something?
No.
You know, I lived in one that had a notification said you cannot have short-term rentals or anything less than 30 days. And so there were no short-term rentals in that entire neighborhood. I live in another one now that does not address anything. And so we do have out of 400 and some residences, there are like 17 short-term rentals. If they were to adopt something within the CCNRs that would be more stringent than the county, you said, will that or not, will that not really be applicable? You know, because there's no consequence if they say nothing less than 30 days, but they do it anyway, there's no consequence. Is that what you're saying?
No, what I'm saying is that the CCNRs and an HOA are a private contract between private parties. And the county is not a party to those CCNRs. You have no ability to enforce the CCNR provisions because you're not a party to the contract, right? It's a private agreement between private parties. And if you feel one of your neighbors is violating the terms of this contract, you would sue to enforce the contract. But the county doesn't get involved. It's just not a county matter.
Okay, thank you. And then the second part of that is on the, I know your lawsuit was more about land use, not code compliance, but was there any discussion during the process about code compliance and how that affects, you know, the situation?
Well, sure. I mean, you've sat through the meetings, right? There's lots of comment about nobody's enforcing these and me and my neighbors and this one across the street. There's lots of discussion about enforcement. As a practical matter, that's something I always think about whenever somebody is considering, a city or county considering of making a law. How are you going to enforce it? And if it takes all of the county resources to enforce it, is it a good idea? In this case, there are companies out there, they don't cost very much, that just set up algorithms and they will search the internet for who's advertising a short-term rental within your jurisdiction and provide you a report monthly. And you can either give them a list of the licensed locations and they'll match it up, or you can match it up, you know, your staff can do it. But yeah, there are companies out there that will keep track of who's advertising short-term rentals in the county. And you can just match that up with the list of who's got a license and find out who's not getting a license. Now, going further in like occupancy limits, and if you've got a parking requirement and those kinds of things, then it becomes a code compliance issue. And you have to, you know, if you get enough, my guess is your code compliance system is triggered by complaints. And so if you get enough complaints, it'll trigger enforcement. So in terms of the licensing, you can hire a company that will keep track of the number of people advertising in the county and make sure everybody gets their license. And then beyond that, it's a code compliance issue.
Thank you, Mr. Crean. Commissioner Thompson?
Thank you. Well, Chris, we've been down this road for these many years. I've been a particular advocate of this. What I'm concerned about is neighborhood livability. And that relates to every single person who comes here, because we can track short-term rentals. We can track short-term rental usage. We can track valid complaints and distinguish them from complaints that I would consider frivolous or malicious. We can do all that. But we have so many more people now in Oregon that what I'm concerned about is how we manage change together with some grace, with some compassion, with some effort to behave well to one another. That isn't land use planning per se, but that's what I'm looking at is the interaction between the law and human behavior. So that's why we looked at the good neighbor agreement. So I think we've come down the path you've described. We've attempted to go beyond that by asking for good neighbor agreements, but they aren't universally applicable. We don't have any impact on day trippers. We don't have any impact on part-time owners. We don't have any impact on full-time owners. So how do we help each other get to the place where we treat each other well? That's beyond your scope, I think.
Right. The intersection of the law and human behavior is why I will never lack for work. Right. I apologize. As a quick aside, I should have mentioned this at the beginning, but I'm scheduled to meet with the Lincoln County Board in executive session at 11. We have some litigation going on, you might have heard. And so they are meeting at 11. And so I will have to leave you at that point. But it sounds like this very quickly wraps back around to the policy discussions, right? Livability versus property rights versus administrative costs, those kinds of things are all of the sort of policy considerations that you have to weigh and balance. I actually gave a presentation on this at a legal conference last week, and there were a number of questions that came up. And at the end of the day, I said, this whole thing reminds me of a phrase I learned during my river rafting days, which is watch the water, not the rocks, because if you watch the rocks, you will hit them. And there are a number of rocks out there: property rights, neighborhood livability, administrative costs, and your job is to find the clear water and navigate between all those. And I don't envy you your task.
Yeah, thank you, Mr. Crean. And we don't want to keep, I know you probably need to prepare for your next meeting there, but I see that Commissioner Banks has another question. Commissioner Banks.
I don't know so much if it's a question, but it brings up the thought process of equity. And, my daughter just participated in a softball tournament with her tournament team here. And we had the joy of being able to finally do it in Seaside. And looking at the stands and realizing that a lot of these families probably wouldn't have been able to make that trip if they hadn't have been able to get a short-term rental. It was during obvious, high season for our hotels and our motels, and costs are through the roof for a family to rent a hotel room for a weekend. And I listened to a child in the stands talk about a house that they had all to themselves. And she was 5 or 6 years old, and she was thrilled that she could come visit, and she had a house, and her family had a house all to themselves, not just a tiny little hotel room. They had a kitchen. And it just really hit me hard that in this discussion, there is another situation of equity out there where families are trying to travel and visit our great area. And this is also a situation where it allows them to do so. It's financially feasible for them to do so when it would be otherwise not financially feasible. This is a thought for me. Considering we've already passed and 2020, now moving forward, I think we have next up to the plate is caps. And I guess I'm looking at this and I see one specific region that is highly at play here, and then multiple other regions that the rentals are very low. It's not as an extreme conversation in the other regions east of 101. And so is there a way that we can release or set a cap east of 101 while we discuss west of 101, the more heavily inundated concerning region?
Yes, I mean, I think you just articulated a rational basis. There are the impacts, there are undeniable impacts from short-term rentals. And so you can reasonably focus on those portions of the county where the impacts are currently the greatest and try to address those and set aside the other areas of the county until you've wrestled with the biggest problem, right? So that's a perfectly legitimate reason to distinguish one part of the county from another, east of the highway versus west, for example.
Excellent. Well, I appreciate your time so much. You've definitely shed some light on the situation, and I just want to make note, I love how you took us through that story. My brain appreciated it. It was very and explained Lincoln County's issues. I really appreciate it.
Good, thank you. Joanna is almost as conversant with these issues as I am, but please feel free to reach out to me if there's anything she can't answer, if you need anything else from us.
Thank you very much, Mr. Green. Do we have any last minute questions? I appreciate you're in high demand, so thanks for your time today.
Thank you.
Appreciate it very much. Let's move on to our next item, which is the discussion, or excuse me, the biannual Clatsop Behavioral Healthcare Update. Executive Director of Clatsop Behavioral Healthcare, Amy Baker, is with us. Thanks for your patience, Amy. We'll go ahead and turn it over to you. This begins on page 3 of our agenda.
Commissioner Aquila and other commissioners, thank you for letting me sit in on that scintillating discussion. Teresa, are we going to do the PowerPoint, or do you want to just look at the slides while I go through them?
You're welcome. Oh, did you want me to share the slides? I assume I gave you rights to share your screen. If
you did. All right. You remember this didn't go so well last time. I got it.
Okay, we can see them.
So obviously, my name is Amy Baker. I'm the Executive Director of Clatsop Behavioral Healthcare. And with me today, I have Shira Marilla, who's the Chief Clinical Officer of Clatsop Behavioral Healthcare. So over this past year, from June 2021 to May 2023, we served 1,887 unique clients. On average, we provided about 20 hours of service for all clients, with the median hours of about 5. So that includes folks who come in for an assessment, but that's all they end up getting. Access to mental health and substance use disorder services has been, I would say, very challenging over the course of the pandemic. And as you all know, we made some pretty significant changes to how we do business in order to accommodate that. And that included opening the Rapid Access Center. The data on the left shows that for individuals who called to schedule an appointment, the average wait to get in was about 9.75 days, whereas walking in was about a half day from the time that they walked in that we were able to enroll them into care. I'm working on getting better data on the number of folks who are walking in versus scheduled, but I don't have that at this time. Once somebody's been assessed and they decide they want to do services, it's taking about 14 days to get them scheduled with an ongoing clinician. Our adult psychiatry is a little over 20 days, and child psychiatry is like around 26. That's really good in comparison to other organizations and nationally. As you all know, we've done a lot of work on increasing our outreach into the community. There's a significant number of folks who are not ever going to call and schedule an appointment and come in to see us, and so we have to go find them. And that includes services like our mobile crisis team and our recovery allies. Over the last year, we provided 300 crisis assessments. About 89 of those individuals had moderate to high suicide risk. So obviously that's good that we're meeting them in the community. Our response time is under the requirement of, I think it's 2 hours for, it may be an hour for rural. The reality is that if we don't get there fast enough, people don't tend to call us. The Recovery Allies have done outreach with about 338 individuals. 244 of those referrals came from law enforcement, hospitals, et cetera. 94 were people who sought out the Recovery Allies on their own. And our peers provided over 2,000 hours of service. This is just a snapshot of what, like, the kind of the primary programs that clients end up being enrolled in. I didn't include all of them because this graph would have been a mess, but these are kind of the main programs. The smaller programs like Wraparound and ACT CSS, those are like high intensive programs. So we have smaller numbers of folks who are served in there, but they get a whole lot more service. Our medication assisted treatment program that we started years ago in partnership with Columbia Memorial Hospital is growing. We're continuing to get more and more clients into that program, in part because of access to Fora Health that's doing inductions for us, and that also that we're located with the pharmacy right there on site. It's made it a lot more convenient for folks to get those services. This slide is for you, Commissioner Webb. So it's really hard to track outcomes for clients, in part because they're not all starting from the same starting place. If somebody, when we first start to work with somebody, if they're experiencing homelessness or have a more serious mental health or addiction disorder, typically the length in treatment is going to be a little bit longer than somebody who has moderate depression. What we do know is that one of the most important factors, though, is how long we keep people in treatment. Retention is everything. And the longer that folks are involved in treatment, the more likely they are to experience relief from their symptoms. So in the last year, from June 1st to 2021 to May of 2022, there were 571 clients who engaged in services and discharged by the end of that year. For the clients who discharged without having a completed episode of care, like their average days of treatment was about 92. For clients who actually went through a full course of treatment, agreed with a therapist that they felt better and closed, the average number of days was about 143. And of the folks who are still open and active, they're up to 179 days of active treatment. This is important because of, like, Scott Miller's work, is that what he discovered by doing a meta-analysis of a lot of different treatment studies is that about 60 to 65% of people experience symptom relief within 1 to 7 visits. So we know and then 70 to 75% of the people that were studied experienced symptom relief after 6 months, and 85% at 1 year. So this is a number that we track and we look at and we pay attention to, because we want to increase client retention and services. And if I could just tell you a quick story about a particular client that we started serving several years ago. He worked with the Recovery Allies and with our MAT program, but he had 5 or 6 referrals to detox. He had 3 different inpatient stays in substance use disorder residential treatment. And he kept relapsing. At one point, he was sleeping on the front door of our Seaside office. And last year, we got him into detox one more time. And for some reason, this one stuck, and he came out. He enrolled in our medication assisted treatment program. He lived at Helping Hands for a little while. He was going to AA consistently. He got a sponsor. He moved into our Warrenton duplex, our recovery housing that we just opened last summer. And he's now a model resident. He's mentoring the other guys who are coming in. He's been volunteering about 20 hours a month. And for the first time in years, he's got functional teeth, and he's looking at long-term employment. And I think that's a really important story, that if you looked at one episode of treatment, it wouldn't look like a success. But when you look at what we've done with him over the last 2 to 3 years, it's pretty heartwarming. So this slide basically demonstrates some of the work that we've done around our equity and inclusion initiatives. 2 years ago, we embarked on a journey to really work on how we're perceived in the community, what we understand about equity and inclusion, and being an organization that does not perpetuate racist policies and acts. And we intentionally used the pandemic to increase the number of clinicians that we have who are bilingual and bicultural. And if you look at the Latinx population, we almost doubled it in 2 years because of that. And we've also increased services to other populations, including other single race and 2 or more races. I can't exactly speak to what all led to this increase. Part of it was our social media campaign. Part of it was our training initiatives. And part of it is the quality improvement committee that we have that very openly addresses this. Now I'm going to turn it over to Shira to talk about some of the trends that we're seeing out in the community. Shira.
Thanks, Amy. Yeah, we just wanted to highlight some of the, I think, primary challenges that we're seeing in our work right now. Fentanyl being at the very top of the list. For those of you who don't know, fentanyl is a synthetic opioid that's about 50 to 100 times more potent than morphine. And it is all over our community. The overdose rates have increased by about 56% just since 2019. And then that definitely accelerated even more throughout the course of the pandemic. So basically for people who used to primarily use heroin, they are reaching for heroin that is also inclusive of fentanyl, which increases the euphoric experience and also, like I said, increases the overdose risk pretty significantly. The other challenge with fentanyl is that it's not just mixed in with other opiates. It's also people are lacing all forms of substances with fentanyl. So people who typically are not or were not previously addicted to opiates, who were maybe addicted to meth. Meth is also being laced and mixed with fentanyl. And so we end up having people who are now struggling with opioid addiction in addition to their prior addiction, which may have been meth. We've even had reports of fentanyl coming up in cannabis use. So people who just think that they're going to smoke some marijuana, which they've bought on the street, is also being laced with fentanyl. And then similarly, meth has changed pretty drastically over the last, I would say, 2 to 3 decades, and is significantly more dangerous than it has been historically. The meth that we have on the streets now has increased the experience of psychotic episodes, the onset of psychosis, and also long-term psychiatric effects, which we have seen is inundating our Oregon State Hospital, and is just increasing the acuity and experiences of mental health experiences and disorders across the board. So those are 2 huge challenges for us. I also wanted to highlight, just going back to fentanyl really quickly, we typically treat opioid addiction with medication-assisted treatment. So there are prescriptions that we use, Suboxone and methadone and naloxone, to treat opioid addiction. The challenge with fentanyl is that we found that clients who are on prescription medication, like Suboxone, can actually continue to get high if they use fentanyl, which previously was not the case when they were just typically using heroin. In addition, it is creating questions about our treatment models for opioid use disorder, because we potentially have to increase the type or amount of prescription and potentially the type of prescription that we're using. So those are big challenges. And then moving on to increased crisis and acuity in clients, we're just seeing that people are sicker across the board when they're coming into our clinics. We can see the impacts and effects of the two substances that I was just talking about. We're also seeing the impacts of prolonged stress from the pandemic, in addition to fractured social supports and people just being more and more isolated. We're also seeing the impact of Measure 110, which changed the possession laws. And so people are not necessarily being arrested for possessing illegal drugs. And so by the time they end up being in a lot of trouble, they end up being in a lot worse shape. And then two big things, obviously, we don't have any affordable housing in this county. And so if people don't have a place to live, then we don't really have a good way to treat their addiction or mental health conditions. People don't get better on the streets. And so in the absence of having places for people to live, we will continue to see increased acuity and a growing population of people in a lot of need. And then, of course, inflation also really contributes to people not being able to meet their basic needs, which is causing people to be a lot sicker, a lot more people and a lot sicker.
So organizational health wise, we have experienced the same hiring challenges that other local businesses have. And I think it's been particularly challenging for the behavioral health field, in part because the state has really maintained flat payment rates for behavioral health for the past probably 5 years. And after the pandemic, we just saw a lot of burnout and rapid turnover of staff. We finished our bargaining process with our union, and due to rate negotiations, we were able to increase our salaries between 12 and 19%. We're hopeful that will create more organizational stability. We're still having a hard time hiring master level clinicians, as is every other behavioral health organization in the state. Our staff turnover rate is probably better than the national average, but still not great. I think it's somewhere around like 29%, with residential having the highest staff turnover. And our vacant positions right now stands at around, we're probably somewhere around between 5 and 10% vacancy, which is actually really good. And some of those positions are like brand new positions. So compared to my peers across the state, I actually think we're doing pretty good. We continue to focus on projects that we think are going to help our clients, and that includes permanent supported housing. My goal is to have somewhere around 50 units of permanent supported housing within the next 2 to 3 years. We want to look at doing whole person care. It doesn't do any good to keep somebody mentally healthy if they then die of their diabetes. And so we're looking at ways to expand our ability to provide primary care. With the 988 rollout, we're expecting to receive additional funds for our mobile crisis team so that we have more capacity to have behavioral health folks respond to behavioral health crisis. We're in negotiations with the state right now, and I don't expect to see anything concrete happen with that for probably another 3 to 4 months. We recently received a grant from the state to increase our substance use services. And so that includes more CADC, like drug and alcohol counselors. We're also going to be able to, when the jail is ready and the new jail is up, to be able to provide medication assisted treatment to individuals in the jail to reduce risk of overdose when they come out of the jail after having a period of sobriety. And then, Shira, did you want to talk about intensive in-home for kids? Because we never talk about kids, and we should talk about kids.
Sure. So we started a new program in the kids department. It's called IIBHT, or Intensive In-Home Behavioral Health Therapy. And it's, we're in early phases of rolling out that program. We just have a couple of clients who are engaged in that, but it allows for an opportunity for families to engage in and commit to at least 4 hours of clinical intervention in their home or in the community in a setting that they choose. And so they'll work with master's level clinicians, as well as peer supports, skills trainers, just kind of depending on what the family really needs and really is looking for. They sort of get to choose off a menu of different interventions to equal up to 4 hours or more of intensive services, like I said, in their home or in the community. So that's a brand new program.
And the last thing I wanted to add was that we recently, with Clatsop County, had a conversation with ODOT about things that we could do with ODOT, and actually with Commissioner Thompson, about things that we could do to increase safety with the Megler Bridge, specifically as it relates to people who use that site to attempt to end their lives. And I think the conversation was really productive. ODOT mentioned that that really, to do any kind of structural changes to the bridge, it would require a feasibility study that involves engineers, given the complexity of the way the bridge is built. And we also talked about doing in addition to that, something more immediate that would involve like a public awareness campaign around call law enforcement if you see someone on the bridge. There's not a lot of evidence that crisis line numbers will prevent somebody from attempting to end their life. But if we can get somebody there and somebody in person, our chances of intervening sooner are a lot better. And I would invite either Dawn or Monica to speak to that if there's anything that I missed.
No, thanks, Amy. Just real quick, Chair Quaylen, members of the board, I think that it was a very productive conversation. I think the sheriff and the chief, Kelly from City of Astoria, as we talked about surveillance, I think it really became clear that the best surveillance are the many, many, many drivers that go over that bridge every day, all day. And so, educating folks and encouraging folks to be aware and to feel comfortable calling 911 when they see somebody walking on the bridge or being on the bridge would be a good first start. And I think that kind of a public education campaign pays a lot of other dividends, just to make people aware, of the struggles and being good guardians of others. I just think this falls into the grace that we would talk about all the time, which is really being good to other people. And so I think this is a community response. Certainly, we are going to pursue other options and be a partner with ODOT as we try to attain funding that might help with the feasibility study, and Commissioner Thompson and PacWest will be talking about that. But I think there is an immediate need, which is just to let people know that it's illegal to be on the bridge if you're a pedestrian, and then to have them help us, because that's the best early warning system. So that's all that I have. Thanks, Amy.
Yeah. And that's the end of my presentation. So I don't know if there's questions.
Yeah, thank you very much for the update. Do we have any questions for Executive Director Baker or for Chief Clinical Officer Marilla? I see that we have two, Commissioner Thompson and then Commissioner Banks. Commissioner Thompson.
Thank you. So Amy, I gotta love it that you bring us the gnarliest problems and the gnarliest solutions always. You know, I appreciate you take on that role. I love the idea that we're talking about a campaign that tells people save a life, call 911. Because if we cue people in to how to be there, how to be that helping neighbor to help save a life, I think that's really important. Amy, when I saw this report, I had to appreciate that you've taken into account the impacts of ballot measure 110 as much as you can right now. I'm told that the burn money, that $6+ million, should have a positive impact. Can you anticipate a little bit what that burn program will do for us, what you'll be able to do with it?
Yeah. So it was a partnership of like 6 entities that all applied for funding. And the probably the biggest chunk of funding is going to go to housing and shelter, which is undeniably one of our biggest needs in this county. And so that includes Helping Hands is going to remodel and purchase and remodel the site down in Seaside so that they're able to offer year-round shelter, which is great. That's something we don't have right now. And having it be not just for folks who are trying to get clean and sober, but for folks who may not be ready for that yet. CCA is looking at increasing their capacity to do like rental vouchers, and also they're looking at doing like micro housing, pending finding a site. But that's kind of the major project that they're working on. There's an entity called Iron Tribe that is new to our county. They provide recovery housing for families so that moms and kids can stay together in a housing program. And then CBH will have enhanced services. We expect with more shelter and more programs, we're going to see increased demand for services. And so we really want to be able to ramp up for that. We're also really excited about our partnership with the jail because I know that there's been a push to not want to criminalize substance use, and I get that, but our system right now is not set up to catch people in other ways, and jail really is an opportunity to get a break and a chance for us to develop a relationship with somebody and get them started in treatment that has the potential to positively affect their lives. And then also we think it's going to help us with some of our housing, particularly the five bed transitional housing program that we're hoping to open in November.
Can I jump in, Commissioner Thompson, really quick? I just wanted to add also that the number of like shelter beds and permanent supported housing that we will be acquiring through this funding is still only just a fraction of the number that we need and that we see, right? So like this is important, and it's just a beginning to address the epidemics that we're seeing in our community. In addition, MAT specifically in the jail that we're talking about focuses on opioid addiction and not meth. There's still not really a lot of appropriate interventions for people that are addicted to meth, so we need more funding, we need more opportunities and more interventions, because it's really meth that is contributing to the inundation of our Oregon State Hospital, which is a huge problem for people across the board.
So that's fabulous. I really want you, insofar as you're able, to track those data of the unmet need and report them to us. I mean, we've said this before. We can't say it too often. Help us help you track and meet the unmet need. Help us do that, please.
Great. We will. Thank you.
Commissioner Banks.
So I just have a question. You mentioned pediatrics, and I really feel like if we can reach the underage, hopefully later on in life, and prevent a lot of the continuous.
Commissioner Bangs, I think you cut out there. You've had some issues there today. Yeah, we can't hear you.
I am having internet issues. Can you hear me now?
Yes.
Okay.
We lost you again. Do we have any other questions from the board?
And
Yeah, sorry, Commissioner Banks, we lost you. Any other comments? Well, we really appreciate the update. Thank you so much, both Executive Director Baker and Chief Clinical Officer Marilla. And we will move on to our next item, which is a related topic. It's the Clatsop County agreement with CBH for mobile crisis services. We have Amanda Rapinchek, who is our management policy analyst, and she's going to present on this. So I'll turn it over to Amanda.
Thank you, Chair Quaylen, members of the board. Can you hear me all right?
Yes, we can.
Awesome. So this agenda item is about the county's agreement with CBH for mobile crisis services, and it's in regard to the ARPA funds that were allocated to support this agreement. So in year one, so that'd be fiscal year 2021, 2022, the county dedicated $80,000 towards this agreement, and the scope of work, it's outlined in the agenda item summary, but it includes hiring, training, and supervising clinicians, and kind of just mapping out the perimeters for the coordination with law enforcement and that partnership. And so Amy talked a lot about those outcomes and kind of the impact of that program. And so this is an opportunity for the board to consider for year two funding. What the county had estimated would be designated for year two is $160,000 for continued support in a year two contract. So that would be for this fiscal year 2022-2023. So I just want to invite the board, if they had any feedback in regards to the outline funding, if that was still felt appropriate, or any sort of adjustments with the agreement.
Okay, I see Commissioner Thompson has a question.
I just hate being the one who says, but how are we going to pay for this later? Because this is great, it's needed, but the need won't go away. And I'm concerned about sustainable funding going forward after the ARPA money runs out, trying to anticipate how to create sustainability.
You want me to speak to that?
So yes, sorry, Amy, I was everybody's trying to see who's going to speak up. So Amy, if you want to speak to that, that would be great. And then I can chime in if necessary.
So, so what I love about this contract is that it's allowed us to do our, we hired 2 law enforcement liaisons. And so we have 2 mobile crisis clinicians who are paired with the Astoria Police Department and also the Clatsop County Sheriff. And we've been like co-responding to calls, and I think it's been really useful from the standpoint of improving our relationship with law enforcement, but also having a co-response to behavioral health conditions. As I said in my presentation, we are expecting there to be increased mobile crisis funding that's coming from the feds to the state to us. I think, and it's going to take a while to implement that. And there's a question mark about whether or not the state's going to support co-response. Like, we're not the only county that does that. Washington County does that as well. We think it's a really good model, but this gives us at least another year to be able to work that out and figure out what the model is going to look like going forward, so that in the event that when the funding ends, we will hopefully have additional revenue to pick up those positions.
Thank you, Director Baker. Go ahead, Assistant County Manager. Did you have something you wanted to add?
I think Commissioner Thompson had another comment or question.
I just wanted to say, when Senator Wyden came to town, thank you, Assistant Director Steele. When Senator Wyden came to town, he could hear the respect, the affection, the great collaboration on the ground between our law enforcement and our mental health people. He was delighted and impressed. So I think that our community credibility and the good work that you've done has found a receptive audience. And I can imagine that will lead to greater federal support going forward. Thank you.
Thank you, Commissioner Thompson. Do we have any other further comments or questions? And as far as the feedback on the year 2 proposal, are we all fine with that? Yeah, fine with what's proposed. Okay. Great. While I have Director Baker on, I have a question because Courtney couldn't get through there. Commissioner Banks was having problems. She wanted to ask, what is the wait time for new patient intakes for peds and adults? How long a parent has to wait for assistance? That's what Commissioner Banks' question was.
Ira, do you want to take that?
Kids' psychiatric appointments, is that the question?
I would do both. I would talk about getting into services and then also psychiatric.
Okay. The slide that Amy showed represented under 9 days for new appointment access, which is inclusive of our kids statistics. And then under 26 days for child psychiatric appointments, so for medication. If we have walk-ins, our rapid access clinic is primarily built for adults. And the reason being, the folks that tend to visit that clinic are likely not the population that we necessarily want mixing with our kid population. So we haven't really invited kids to drop into that clinic in the same way that we have invited the adult population. As you can imagine, if someone is high on meth and experiencing a lot of psychiatric problems, it might not be a good place for children to wait in the lobby. But we are working on expanding our walk-in access for kids. And if we are able to do that at our 12th Street clinic, then we could meet that half-day mark that Amy referenced, which is the access time that it takes when people actually drop into our rapid access clinic.
Thank you for that additional information. I see Commissioner Banks has her hand up. We'll see. Go ahead, Commissioner Banks. No, it's not coming through.
Something.
Can you put it in the chat?
Darn it.
Yeah. Or text me. Okay. Sorry, Commissioner Banks.
I just want to add to that because of the intensive in-home for kids that first of all, we have clinicians who are like located in all the different school districts. And so that I think is extremely beneficial, particularly when schools are identifying needs that kids might have. We're also, because of the intensive in-home, it allows us to move more quickly when we hear about kids being in crisis. And I've seen us be able to get kids in, particularly when it's urgent, like in within a day or two. It just requires somebody notifying that the kid needs to be seen immediately. And so ideally we'll have walk-in capacity at some point for kids, but it's having enough clinical folks who are not scheduled to be able to do that. And it's hard to not schedule clinical folks when the need is so high, but we're working on it.
Thank you, Director Baker. And going back to the item, doesn't sound like we have any additional feedback on what's proposed for the mobile crisis services in year 2. So we'll move forward on that. And that is the last item on our agenda. Thank you so much, Director Baker and Chief Clinical Officer Marilla. And do we have any items for the good of the order? Nope.
We're working on broadband, I swear.
Working on broadband. Yep. Good job, Commissioner Thompson. We appreciate your hard work on that.
Man.
Not seeing any, we'll go ahead and adjourn. Thank you very much. Have a good rest of your Wednesday. Take care.